The official autopsy report on Nolan Wells is complete. It's finished, reviewed, sitting inside a file at the Jackson County District Attorney's office right now. And almost nobody outside that office has actually read it. Not the family, not Ben Crump, not the independent forensic pathologist who traveled to examine Nolan's body a second time and came back with a finding of undetermined. Not the 60 witnesses who've already been formally interviewed. Not the substantial reward that's been sitting active, unclaimed, for weeks. The state of Mississippi finished examining Nolan Wells' body. Investigators know what they found, and almost none of it is public 6 weeks after his death. This is Forensic Disconnect. We want to start this episode there at that specific fact because we think it changes how carefully every other piece of information in this case needs to be weighed. It's not that the sealing itself is unusual. In Mississippi, unnatural deaths generally go to a grand jury before autopsy results are released, and District Attorney Angel Myers McElrath confirmed that publicly, on the record, well before this case became a national story. The process appears to be following the actual standard procedure, one that predates this case entirely and applies equally to every unnatural death this same office has ever handled. But there's a real meaningful difference between information being withheld for legitimate, ordinary procedural reasons and information simply being unavailable because the public record doesn't currently contain it at all. 6 weeks in, most of what's being debated online, on panels and comment sections, and across dozens of competing channels, is built from an incomplete picture, not because anyone covering it is doing something wrong, but because the complete picture is sitting in a sealed file that only a small number of people have actually seen. That gap between how much confidence commentary projects and how much verified access actually exists behind it is really what this entire episode is about, and it's a gap that's going to keep widening for as long as this case remains sealed and this much national attention keeps flowing toward it. Before we go any further, the standard disclaimer that applies to every episode we make on this case. No charges have been filed in connection with Nolan Wells' death. No arrests have been made. Investigators have not issued a final public determination on the manner of his death, and won't until the grand jury has completed its own review of the sealed evidence. The independent autopsy found cause and manner of death undetermined, pending further investigation. The state autopsy is complete but sealed pending grand jury proceedings. Every individual referenced in this episode is presumed innocent, unless and until formally charged and convicted in a court of law. Nolan Xavier Wells grew up in Ocean Springs, Mississippi, close with his mother, Christine Wells Wansley, and his father, Elmore Wansley, a first-year wide receiver for Southwest Mississippi Community College with, by every account, an unusually wide circle of friends across different social groups. On July 4th, he traveled to Horn Island with a large group of friends split across multiple boats, joining somewhere between 1,000 and 2,000 other people who'd made the same holiday trip out to the island that day. According to those friends, Nolan chose to stay behind on the island that afternoon rather than return with the group he'd arrived with, a decision his parents have never accepted without serious reservation, pointing to the fact that Nolan didn't have his phone with him when the boat departed, among other unresolved details. Let's start with a detail from this case that we don't think has gotten the attention it deserves. And it comes directly from an official government agency's own public acknowledgement rather than from anyone's speculation. The Mississippi Department of Marine Resources, the state agency that tracked GPS data from the boats involved in this case and has been part of the official search effort from the very beginning, publicly admitted it inadvertently released records related to Nolan's death. Those are the agency's own words, inadvertently released, stated in a letter responding to a public records request filed by TMZ, not a phrase supplied by any commentator or attorney trying to characterize what happened. We went back and confirmed the specific language of that letter because we think it's worth quoting precisely rather than paraphrasing. The MDMR told TMZ it had previously released records in relation to this matter, by mistake, in a letter dated Wednesday, July 22nd, and that it was subsequently notified by the Jackson County District Attorney that Nolan's death remains under investigation, will be presented to a grand jury, and that the records in the agency's possession related to this matter are exempt from public disclosure. The DA asked the MDMR, in writing, to refrain from releasing any further protected information going forward. The agency also returned a $50 processing fee TMZ had paid for the original record's request, a small, almost bureaucratic detail, but one that confirms this wasn't a vague or informal acknowledgement. It was documented enough to involve an actual refund tied to the specific mistaken release. We think it's worth walking through what that sequence actually implies, because it's easy to skim past a story about records being inadvertently released without stopping to think about what that phrase is actually describing. Some records connected to the MDMR's involvement in this case, potentially GPS data tracking the boat's exact movements that afternoon, potentially internal vessel documentation, potentially the agency's own reports compiled in the days immediately surrounding Nolan's disappearance, went out to the public before anyone in an official capacity had determined they should be released at all. The agency hasn't specified exactly what was released or to whom. What's documented is that something went out that shouldn't have, and that a sitting district attorney then formally intervened in writing, invoking a specific legal exemption tied to an active investigation. That sequence tells you something meaningful about the underlying material, even without anyone outside that small circle knowing its specific contents. If those records were genuinely routine, purely administrative documentation, with nothing that bore on the actual investigation, a prosecutor typically has little reason to step in and formally instruct an agency in writing to stop releasing records under an active investigation exemption, rather than simply letting the requests continue unremarked. That specific legal tool tends to get invoked when the records in question are actually part of the active case file, material a prosecutor doesn't want circulating publicly and out of context before the grand jury has had its own proper chance to review it directly. That's not our interpretation stretching beyond what's documented. It's the DA's own stated position, on the record, in writing, which is precisely the kind of distinction between inference and documentation we're going to keep drawing throughout the rest of this episode. There's a useful, more general way to think about why prosecutors reach for this specific legal exemption, one worth explaining rather than simply asserting. Under Mississippi's public records law, government agencies are generally required to disclose records upon request unless a specific recognized exemption applies, and records pertaining to an active investigation is one of the narrower, more targeted exemptions available, deliberately designed to be invoked only when disclosure would genuinely risk compromising a case, rather than as a blanket excuse for withholding anything a prosecutor would simply prefer stay private. Prosecutors who invoke that exemption too broadly, or without real justification, risk exactly the kind of public records challenge that journalists and advocacy organizations pursue specifically to test whether an exemption claim actually holds up. That McElrath invoked it here, formally, in writing, addressed to another state agency rather than simply declining a request informally, suggests she considered the underlying material significant enough to justify the more formal, legally exposed route rather than a quieter, less accountable one. It's a choice worth contrasting with how easily this same situation could have been handled more quietly. A private phone call, an informal request, nothing that would ever surface in a subsequent public records request from a media outlet. Instead, the exchange happened on paper, which is precisely why we're able to discuss it in this much detail today. Now let's turn to the DA's own public statement, because it deserves to be read in full and carefully, not compressed into a single soundbite the way it's been treated in some corners of this case's coverage. On August 18th, 6 weeks into the investigation, McElrath addressed the mounting public criticism of her office's handling of the case directly, for the first time at this length. She said that as district attorney, she doesn't have the same freedom to share information publicly that private individuals do. She specifically noted she cannot release letters she sent during the investigation, cannot discuss witness cooperation, and, critically, cannot identify which pieces of information circulating publicly are verified and which aren't. We want to quote her more fully here because her exact language matters, and it's the kind of statement that reads very differently in full than it does compressed into a 10-second clip. As district attorney, she wrote, "I do not have the same freedom to share information publicly that private individuals may have. For example, I do not have the freedom to release letters I've sent in this investigation, discuss witness cooperation, or the testing of evidence. I do not have the freedom to identify what information is verified and what information is not." That's a prosecutor stating, on the record, the specific boundaries of what she's professionally and ethically permitted to say. Boundaries that apply to her regardless of how much pressure builds around her office from any direction, whether that pressure comes from grieving family members, national civil rights figures, or the millions of strangers online demanding immediate, specific answers. She is not legally free to give any of them right now. We want to sit with that last point specifically because we think it's the single most important sentence in her entire statement. She cannot identify what information is verified and what isn't. That means she is, right now, sitting with access to the sealed autopsy, to witness statements, to whatever records the MDMR released before she intervened, watching a public conversation unfold around this case that may, in places, directly contradict or complicate what's actually documented in that file, and she is legally barred from correcting the record, one way or the other, no matter how loudly the wrong version happens to be circulating at any given moment. Some of what's been reported, analyzed, and confidently asserted across dozens of channels covering this case, this one included, may hold up completely against what's in the sealed file. Some of it may not. The only person who currently knows which is which cannot tell the public, and that fact alone should recalibrate how much confidence any of us extends to the loudest, most certain voices in this conversation, because those voices, by definition, have the least actual access to the material that would let anyone speak with genuine certainty. We think that's worth applying as a general rule for evaluating any commentary on this case, including our own, going forward. It's a rule that requires a certain kind of discomfort with ambiguity, an ambiguity plenty of people covering this case have every incentive to resolve prematurely, one way or the other, simply because a resolved story is easier to tell than an open one. Certainty is cheap online. It costs nothing to state a theory with total confidence, and confident delivery tends to perform well, generating more engagement, more shares, more of exactly the attention that keeps a channel's algorithm favorable. Actual access to verified information is expensive, slow, and often boring by comparison. It looks like a district attorney's carefully hedged public statement rather than a dramatic reveal. We'd rather be the second kind of channel than the first, even when it means our own episodes end with more open questions than clean answers, and even when that approach costs us some of the views a more confident, more dramatic framing might otherwise generate. We think that trade-off is worth making every single time it comes up. McElrath's statement also included a broader description of her office's responsibility to complete the investigation thoroughly and carefully, without compromise, supported by the evidence and worthy of the confidence of the community she serves. We think that framing is worth taking seriously, rather than dismissing as boilerplate, particularly given a detail that's easy to overlook once a case reaches this level of national attention and pressure from every conceivable direction. McElrath stated publicly on July 23rd that every unnatural death in Jackson County goes to a grand jury as standard practice, a policy she said she's followed throughout her career. That statement predates the Congressional Black Caucus's letter to the FBI, predates the NORN-ICP convention appearances, predates the reward reaching its current total, predates nearly all of the sustained public pressure this case has generated. The grand jury process wasn't announced in response to criticism. It was already the plan, stated publicly, before most of the national attention arrived at all, a timeline detail that we think meaningfully undercuts the narrative that the sealed autopsy is somehow a defensive maneuver invented once the pressure got uncomfortable. We don't think that fact resolves every legitimate question about how this investigation has been handled. There are real, documented issues worth continuing to scrutinize. Questions about the timeline of when various agencies were actually contacted that first night, unresolved details about confrontations reportedly occurring on Horn Island the evening of July 4th that never made it into any official police report, and the MDMR's own inadvertent records release that a prosecutor then had to formally claw back. There's also a documented public statement from a former FBI agent, Jennifer Coffindaffer, who's offered her own unofficial read of the case based on publicly available information, describing it as consistent with an accidental death rather than a homicide, an assessment she's stated carries no formal investigative authority, but reflects her professional read of the pattern of evidence discussed publicly so far. We think it's worth including that perspective specifically because it demonstrates the same underlying uncertainty from a different angle. Even people with genuine relevant professional background, working entirely from the public record, are reaching different tentative conclusions, which is itself a strong signal that the public record alone isn't yet sufficient to settle the question either way. We'd note, too, that Coffindaffer's assessment and Dr. E. Morgan's forensic commentary are both genuinely useful contributions to public understanding of this case precisely because both were careful to describe the limits of what they could actually conclude from the outside, rather than presenting a personal read as though it carried the weight of the sealed file itself. That's the difference between expert commentary that adds value and speculation dressed up in credentials, and it's a distinction worth applying evenly to every voice in this case, regardless of their professional background or how many years of investigative experience they bring to a given claim, ourselves absolutely included. Those are documented, legitimate threads, and we're not suggesting the investigation has been handled perfectly simply because the grand jury referral itself follows standard procedure. What we are saying is that when McElrath describes the sealed autopsy as heading toward a grand jury, because that's the actual pre-existing process, rather than a cover story invented in response to pressure, the documented timeline supports her account. There's a related, structural point worth making here about why grand jury processes exist at all, and why so many jurisdictions, not just Mississippi, default to this specific mechanism for unnatural or unexplained deaths, rather than letting a prosecutor simply decide unilaterally whether to bring charges. A grand jury is composed of ordinary citizens, not law enforcement or prosecutors, specifically to introduce a layer of independent, lay judgment into whether the evidence a prosecutor has gathered actually warrants moving forward with charges. That structure exists precisely to prevent situations where the public simply has to trust a single prosecutor's word about what the evidence shows. Instead, a room of citizens with no institutional stake in the outcome gets to review that same evidence directly. Understanding that structure doesn't resolve the frustration of waiting for it to actually happen, but it does explain why keeping the underlying evidence confidential until that citizen review takes place is a deliberate feature of the process, not a bureaucratic inconvenience invented to frustrate a grieving family. It's worth adding that grand jury proceedings themselves are, by design, conducted outside public view for reasons distinct from whatever might be motivating any specific prosecutor in any specific case. Grand jury secrecy exists to protect witnesses who might otherwise face pressure or intimidation before testifying, to prevent people who are ultimately not indicted from having their reputations permanently damaged by allegations a grand jury declined to act on, and to allow jurors themselves to deliberate honestly without the pressure of public scrutiny influencing their votes in real time. Given how many documented threats and criminal charges have already emerged around this specific case, involving witnesses, officials, and family members alike, the argument for protecting whoever eventually testifies before this particular grand jury arguably carries more weight here than in an average case, not less. Now to the forensic science itself, because we think there's a genuine, widespread misunderstanding circulating about what an autopsy actually can and can't establish, especially in a case involving a body recovered from warm Gulf Coast water after several days. Dr. Roger Mitchell, the forensic pathologist who conducted the family's independent autopsy, a board-certified examiner with a national reputation in exactly this kind of high-profile case, announced his findings at the NACP National Convention in Chicago on July 22nd. His conclusion, stated plainly and without hedging about its own limitations, cause and manner of death undetermined, pending further investigation. He was specific and forthcoming about one particular limitation that shaped everything else about his findings. When Nolan's body arrived for that second examination, the lungs and throat were not present. They'd been retained by the Mississippi State Medical Examiner's Office following the first state-conducted autopsy. Without those organs, particularly the lungs, the primary tissue used to confirm whether water actually entered the airways during an active drowning process, the independent pathologist could not make a determination about the actual mechanism of death. Regardless of anything else his examination revealed, a limitation Dr. Mitchell was transparent about disclosing publicly himself, rather than one that later emerged only through outside scrutiny of his published findings. It's worth explaining why the lungs specifically carry so much forensic weight in a drowning investigation, because it's not simply a matter of one organ among many. When a person drowns while alive, the act of gasping or inhaling underwater typically forces water directly into the lower airways and lung tissue, producing specific, identifiable physical changes forensic pathologists are trained to recognize. A distinctive overinflation of the lungs, sometimes called emphysema aquosum, fine froth in the airways, and water-related changes to lung tissue density that can be documented on examination. If a body enters the water already deceased, that same active drowning process never occurs, and the lungs generally won't show those same specific changes, which is why lung examination is often the single most direct piece of physical evidence separating died from drowning from died some other way than entered the water. Without that tissue available at all, an examiner is left working from secondary, less direct evidence, which is exactly the limitation Dr. Mitchell was describing when he explained why his independent examination couldn't reach a determination on mechanism of death. Forensic scientist and death investigator Dr. Joseph Scott Morgan has offered public commentary on this case, addressing a specific, frequently asked question. If there had been a physical altercation and a body was subsequently in water for roughly 48 hours, what would investigators typically expect to find? His answer is worth understanding precisely because we think it's been misapplied elsewhere in ways that matter. He explained that a genuine physical fight would typically leave discoloration consistent with bruising, and that facial or body strikes might produce abraded areas specifically at what he calls the leading edges, the forearms, the backs of the hands, the knuckles, the places that make contact first in a physical confrontation. He noted the independent pathologist performed what's called coronal sectioning of the face, a series of incisions made specifically to examine underlying tissue, and did not find anything in that second examination indicating blunt force trauma. It's worth explaining briefly what coronal sectioning actually involves, since it's a specific, somewhat invasive procedure worth understanding rather than treating as a vague technical term. The technique involves making a series of incisions across the face, allowing the examiner to fold back tissue layers and directly inspect the muscle, fat, and connective tissue underneath the visible skin surface, areas where bruising or trauma can sometimes be present even when nothing is visible externally, particularly on a body that's undergone significant decomposition or discoloration that would otherwise obscure surface bruising entirely. That Dr. Mitchell performed this specific, more thorough procedure, rather than relying only on a surface examination, suggests he was actively searching for exactly the kind of trauma indicators that decomposition might otherwise hide, not simply glancing at the body's exterior and calling it clean. That level of diligence is itself worth noting as a small, positive data point about the independent examination's overall rigor, separate from whatever its ultimate findings turned out to be, and it stands in useful, deliberate contrast to the kind of surface-level speculation that dominates so much of the amateur commentary surrounding this specific case online. Here's the part we think gets flattened or lost entirely in how this specific piece of commentary has circulated. Dr. Morgan was describing what the independent second autopsy showed or didn't show. He was not describing what the sealed state autopsy contains because nobody outside the district attorney's office has seen it. These are two entirely separate documents. The independent autopsy is public, found an undetermined result, and was explicitly limited by the missing lung and throat tissue. The state autopsy is sealed, was conducted much closer to the actual time of death, and may have had access to tissue and findings the second examination simply never had the opportunity to evaluate. When Dr. Morgan said the independent examination didn't show signs of blunt force trauma, that's an accurate statement about what was available to that specific examiner. It is not, and was never intended to be, a statement about what the sealed state autopsy actually found. This is exactly the kind of distinction that gets erased not through malice, usually, but through the ordinary mechanics of how information travels once it leaves its original context. A cautious expert makes a precise, appropriately limited statement in one interview. A second creator summarizes that statement for their own audience, dropping the specific qualifier about which autopsy was being discussed because it makes for a cleaner, more digestible sentence. A third creator, working from that summary, rather than the original source, repeats the claim with even less qualification. By the time a version of that claim reaches a viewer 4 or 5 steps removed from Dr. Morgan's actual words, the independent autopsy, limited by missing tissue, didn't find trauma, has quietly become, there's no trauma in this case, a claim nobody with genuine access to the full record has actually made. We think this specific example is worth using as a teaching case precisely because Dr. Morgan himself did nothing wrong. He answered a hypothetical forensic question accurately and specifically within the exact scope he was asked about. The distortion happened entirely downstream in how his careful answer got repackaged by people who either didn't understand the distinction he was drawing or understood it and chose not to preserve it because the flattened version made for a cleaner, more shareable claim. That's worth remembering the next time you see an expert quoted in this case. The expert's original words are rarely the problem. What happens to those words 3 or 4 retellings later usually is, which is exactly why we've tried throughout this episode to keep pointing back to the original source rather than someone else's summary of it. We think this distinction matters enormously, not as a minor technical footnote, but as one of the clearest examples in this entire case of how a careful, accurate expert statement gets transformed into something considerably more sweeping once it's repeated a few times outside its original context. The independent autopsy didn't find trauma, and it was limited by missing tissue is a fact. There's no evidence of trauma in this case is a different claim entirely, one the actual documented record doesn't support one way or the other, because the document that would settle it remains sealed. We think naming this specific chain of degradation matters more than simply correcting the one claim it happened to produce in this case, because the same mechanism will keep operating on whatever the next widely shared detail in this investigation turns out to be. It's worth developing a habit as a viewer of asking a specific question whenever a confident claim about this case reaches you. Which document is this actually describing, and has that document itself been made public? If the answer is the sealed state autopsy, the claim should be treated with immediate heavy skepticism, regardless of how it's phrased, because nobody outside a small circle of investigators has legitimate access to that document's contents, no matter how many times a claim about it gets repeated or how confidently it's stated the 5th or 6th time around. The uncertainty here runs in every possible direction at once, genuinely, not rhetorically, and we think it's important to say that plainly rather than implying it leans toward any particular outcome. The sealed state autopsy could corroborate the independent findings exactly. It could contradict them. It could resolve some of the most heavily debated questions in this case outright, or it could deepen and complicate them further, in ways nobody currently discussing this case publicly has any way of anticipating. Nobody outside a small circle of investigators currently knows because it's sealed, and every confident claim you've encountered online about what that document contains, in either direction, is coming from someone without access to it, no matter how many credentials, how many years of relevant experience, or how much conviction they personally bring to stating it out loud. What actually is confirmed, stripped down to only what's been verified across multiple credible outlets and official statements, is this. Nolan Wells was 18 years old. He traveled to Horn Island on the 4th of July with a group of friends for what was supposed to be an ordinary holiday celebration. The boat he was on began taking on water after a bilge pump failure. GPS data from the Mississippi Department of Marine Resources, independently obtained and reported by CBS News, shows that boat departing Horn Island at 4:31 in the afternoon. Nolan was not aboard it when it left. 2 days later, on July 6th, a National Park Service ranger found his body near the northwestern tip of the island, and he was formally identified through dental records, a method used specifically because the condition of a body after multiple days in warm Gulf Coast water at this stage of decomposition often makes visual identification alone unreliable. The independent autopsy found cause and manner of death undetermined pending investigation. The state autopsy is complete and sealed, waiting for the same grand jury process every unnatural death in this jurisdiction is required to go through. Separately, Attorney Ben Crump has retained oceanic engineering experts to examine tidal and current patterns around Horn Island, specifically modeling what those conditions would do to a body over roughly 48 hours in the water, and has also retained audio engineering experts to conduct a full analysis of the original sea tow emergency call. Neither analysis has been publicly released as of this recording, despite weeks having passed since both were first commissioned. 3 individuals in 3 separate states have been federally charged in connection with threatening witnesses and officials tied to this investigation. The family's legal team has filed multiple subpoenas to Snapchat, Meta, TikTok, and Life360, among others, along with more recent subpoenas to Ceto Services International and Ward Marine Services seeking dispatch records, internal communications, and documentation of exactly how that day's emergency call was handled. A significant reward, reported at different points between $125,000 and $175,000, depending on the source, remains active for information that meaningfully advances the investigation. We haven't been able to fully reconcile that specific discrepancy in reported totals, and we'd rather flag it honestly than state a single figure with more confidence than the record actually supports. It's worth spending a moment on the social media subpoenas specifically, because they're a genuinely significant, underreported piece of this case's evidentiary picture, and they illustrate something important about how digital investigations actually work in practice. The requests to Snapchat, Meta, TikTok, and Life360 reportedly seek considerably more than message content alone. IP addresses tied to every login, password reset, and account action, device identifiers, timestamps for every access point, and, in some filings, information capable of identifying other parties present in any conversation involving Nolan's accounts, not just the messages themselves. That level of request suggests investigators, or at minimum the family's own legal team, are working to reconstruct a precise digital timeline of Nolan's final hours and days, down to specific devices and specific access times, rather than simply reviewing the content of whatever messages happen to still exist. That distinction matters technically. Message content alone can be incomplete or selectively preserved, but login timestamps and IP address records are considerably harder to fabricate or convincingly delete after the fact, which is part of why investigators in digital forensics cases generally treat this kind of metadata as more reliable in certain respects than the content of the messages themselves. Subpoenas of this scope typically take considerable time to fulfill, particularly when multiple large technology companies are each processing their own separate legal request, which helps explain why this particular thread of the investigation has produced relatively little public news, despite having been filed weeks ago. A quiet, unglamorous kind of legal process that rarely generates headlines, but that may ultimately matter more to the actual outcome of this case than almost anything discussed on camera. The more recent subpoenas to Ceto Services International and Ward Marine Services deserve their own mention too, because they target an entirely different category of record: the actual operational response to the emergency call placed from the sinking boat. Reporting indicates the request to Ceto seeks essentially everything connected to the incident during a specific window that afternoon, including recordings, dispatch records, and documentation showing exactly who handled the response and how, along with the company's own internal training materials and standard procedures for handling reports of a boat taking on water, seeking, in effect, everything necessary to independently reconstruct that specific window of time rather than relying on any single party's summary of it. The subpoena to Ward Marine reportedly goes further still, seeking every communication tied to the incident, including conversations between the boat's captain, local crew, and anyone else connected to the vessel that day, along with records showing whether that response was ever altered or ended prematurely. Together, these filings suggest the family's legal team is treating the maritime emergency response itself, not just what happened on the island or aboard the boat afterward, as a thread worth independently verifying in detail, rather than simply accepting the responding company's own account of that afternoon at face value. We want to close this episode the way we think this case deserves to be approached at every stage, with the human reality underneath all of the procedural detail we've just walked through. Christine Wells Wansley has said publicly, in her own words, exactly what she's actually asking for. Not a predetermined verdict. Not a specific person held responsible in advance of any evidence. Answers. What happened to her son on that island, in that water, on the 4th of July? Not more, and not less than that. It's a remarkably modest request given everything this case has generated around it. 6 weeks of national television coverage, congressional letters, federal charges against people who've threatened total strangers online. And it's worth remembering that everything else this episode has covered, the MDMR's records, the DA's statement, the forensic detail, the pending subpoenas, exists ultimately in service of that one simple, unmet request. The grand jury process is already in motion, moving on a timeline that existed before this case ever became a national story. The sealed autopsy is waiting to be presented to it. It's worth taking a moment to explain what the oceanic engineering analysis Ben Crump has commissioned would actually attempt to determine, because it's a genuinely specialized field most viewers have probably never encountered. Forensic oceanography and tidal modeling use documented current patterns, wind conditions, water temperature, and known physical properties of a human body to estimate how and where a body would likely have moved over a specific window of time in a specific body of water. Work that's been used in prior maritime death investigations to help establish whether a body's eventual recovery location is consistent with a specific entry point and time, or whether it suggests the body entered the water somewhere else entirely, or at a different time than initially assumed. If that analysis, once completed, indicates Nolan's recovery location is inconsistent with the currents and tides that would have carried a body from where witnesses last placed him, that would be a genuinely significant, technically grounded finding. If it confirms consistency instead, that would meaningfully support the account currently on record, one of the few pieces of pending analysis in this entire case that could genuinely move the needle in either direction once it's finally made public. Either way, it's exactly the kind of specialized, physical evidence-based analysis that deserves more public attention than it's currently received once it's actually released. The social media subpoenas remain in process, working their way through each company's own legal review timeline, and the federal cases against people who've threatened witnesses connected to this investigation continue moving through the courts separately. Nolan Wells was 18 years old. He was set to return to school that fall, another season of the football career his family had watched him build with real, quiet pride. He would have turned 19 this past August. By his mother's own account, he cooked her dinner the night before he left, baked salmon, an ordinary meal on what should have been an ordinary holiday weekend, before hugging her, telling her he loved her, and walking out the door for the last time, an ordinary goodbye neither of them had any reason to know would be one of their last, the kind of small, unremarkable moment that only becomes unbearable in hindsight. Nolan Wells's cause and manner of death remain officially undetermined. The state's autopsy findings remain sealed pending presentation to a Jackson County grand jury. No charges have been filed against anyone in connection with his death. If you have any information about what happened to him on Horn Island, if you were there on July 4th, if you have photos or footage that haven't yet reached investigators, you're encouraged to come forward through the appropriate channels, whether that's local law enforcement, the FBI's Jackson Field office, or the family's legal team directly. A reward remains active for information that meaningfully advances this investigation. We'll continue tracking every one of these threads as they develop. The pending oceanic and audio analyses, the sprawling social media and marine services subpoenas, the grand jury timeline once a date is finally set, and whatever the sealed autopsy eventually reveals once it's presented to that jury, and, potentially, released to the public in some form afterward. We think that's the only honest way to cover a case this consequential, while so much of its actual evidentiary core remains, for entirely legitimate procedural reasons, still out of public view, exactly where the law currently requires it to remain for now. This has been Forensic Disconnect. We unlock the cases that deserve to be remembered.